on this morning's docket. That is case number 111425 in the matter of Ira Dennis Hauber.
So, do I understand you're going to have your prosecutor go first?
The sequence of events is that Mr. Walczak will speak first and the respondent will follow.
Thank you.
You may take a seat at council table.
Well, thank you very much.
May it please the court. I'm Alexander M. Walczak, Deputy Disciplinary Administrator. Chief Justice, with the court's permission, I'd like to reserve 4 minutes for rebuttal.
4 minutes is granted.
Thank you. This is a case of original attorney discipline against the respondent, Dennis Hauber. A panel hearing was held on November the 19th, 2013 on a formal complaint against the respondent alleging various professional misconduct during his legal representation of a fellow Cheatham's capital murder case. There also was a supplement to the formal complaint alleged that the respondent failed to file a timely answer in violation of Supreme Court Rule 211B. The proceedings were contested. After the hearing panel rendered a final hearing report in which they unanimously found that the respondent violated 6 different rules of the Kansas Rules of Professional Conduct as well as Supreme Court 211B. At the panel hearing, I recommended to the hearing panel that if the panel found that the respondent's misconduct was negligent, then the appropriate discipline would be indefinite suspension. I further recommended if they found that the respondent's conduct was knowingly done, that the appropriate sanction would be disbarment. The respondent asked that he be permitted to practice law, but that he be restricted in the future from handling murder cases. The 3 hearing members unanimously found the findings and the conclusions, but 2 of the members recommended the sanction of disbarment. The at-large member recommended indefinite suspension. Before this court, the respondent filed exceptions to the final hearing report and filed a brief. And the brief I distilled down to 3 issues. The first issue concerned that the respondent's claim that because he developed a defense strategy and that that his client, Mr. Cheatham, agreed to it, that he's immune from any type of a discipline from this court for violations of the Kansas Rules of Professional Conduct. The second claim is that his flat fee arrangement did not create a conflict of interest or a violation of 1.7. And finally, he contests that whether or not he filed a timely answer to the formal complaint, hence the panel's finding of 211B. Again, this is an attorney discipline case. The hearing panel analysis was as to whether or not, as to the first issue, under 1.1 competence. And under competence, the hearing panel found 24 specific instances of deficiencies. Some of the deficiencies range basically that this, again, the background for Mr. Cheatham's case, it was capital murder, not a regular felony type of a case. The respondent submitted to this court in another proceedings an affidavit under oath in which he outlined at least 40 deficiencies in his representation, Mr. Cheatham, in the criminal case. some of the most basic ones was that he really had no idea of the law of capital murder, the capital murder trial proceedings. He was not aware as to how to life qualify or death qualify a jury during voir dire. He introduced evidence of a prior criminal conviction during the voir dire as well as during the guilt phase. He had no idea of the second phase of the capital murder proceedings, the sentencing phase, and he did not prepare any investigation or evidence along those lines, or some of the 24 instances of deficiencies found by the hearing panel. Again, under competency 1.1 requires that a lawyer shall provide representation to a client with having legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Under knowledge, the respondent, again, did not know anything about capital murder trials or how to proceed. He did not know how to qualify a jury. He did not know the difference between the guilt and the sentencing phase. He did not know what was admissible. He thought that his client's prior conviction for voluntary manslaughter would be admissible during the guilt phase, and he introduced that evidence, called his client, had him testify, even though that the state was willing to stipulate that he had a prior felony conviction and there would be no way under 6455 or any other available rule for the state to give evidence of the voluntary manslaughter during the guilt phase. Again, he did not know anything about how the sentencing phase of a capital murder case. He did not prepare or did not cause any investigation or present any investigation. Skill, the respondent only experience in a murder case was some 20 years prior to that, where he sat in two cases as second chair, one case the first chair. That was not a capital case. Thoroughness and preparation. The respondent did not conduct any investigation as to really the commission of the crime. What he did do was look at the law enforcement reports, talk to some police officers and some witnesses, and that was the extent of it. There was particularly important in this case was that the respondent had knowledge of a potential alibi. Day before the commission of the murder, the respondent had talked to Mr. Cheatham. He was representing Mr. Cheatham at that time in another felony case in Topeka concerning drugs. There was a suppression motion in which I believe he prevailed. The respondent told Mr. Cheatham to leave Topeka, leave the state, and Mr. Cheatham conveyed that he was leaving Topeka with his brother. Subsequent to the murders, there was another conversation between the two in which the respondent was informed by Mr. Cheatham that the police were looking for him for the murders. The respondent told Mr. Cheatham, "It can't be you because you know you were in Chicago." Despite this knowledge and discussions with the prosecutor before trial, the respondent never filed notice of an alibi and affirmative defense. He never developed it. He was prevented by the court from filing an alibi or presenting an alibi, but he did call Mr. Cheatham, and Mr. Cheatham did testify about an alibi, but again, he never developed it. He did not know that how to look, all the communications between Mr. Cheatham and the respondent was by cell phone. He did not know how to determined from the telephone companies the location of the telephone calls between he and Mr. Cheatham to help establish an alibi. He did not know how to compulsory process for out-of-state witnesses. The respondent relies on as a defense that under this court's opinion, prior court opinion of State versus Carter, that if there is an agreement as to a defense by a defendant and the counsel, that somehow immunes him from any type of discipline or authority of by this court to discipline him. He's confused. In this case, there was no question about the ultimate election of pleas. Mr. Cheatham entered a plea of not guilty. The respondent entered that plea of not guilty. There was no debate there. It's defense strategy of what we're talking about. And what an attorney owes a client under 1.1 is competent representation. That if a defendant wants to pursue a certain type of means or strategy, then that has to there should be thorough investigation, and the pros, both sides of the issues needs to be explained. And then if the defendant decides to pursue that, that's another matter. But that was not done here. On examination of the respondent at the panel hearing, the questions were asked, so well, if the advice given to Mr. Cheatham was in error because you did not know about the law of capital litigation and you conducted next to no investigation, wasn't your advice faulty? So any type of decision that Mr. Cheatham may have made was faulty because he was not provided with sufficient legal advice. And this court has recognized, as well as Kansas Rule of Professional Conduct, Rule 1.12, recognizes that the decisions as to what type of plea, whether it's a judge alone or a jury, or whether or not a defendant takes the witness stand, belongs to the defendant. What we're talking about are the decisions reserved to the attorney here, the strategy and how the means of litigating the case. It is those deficiencies that are present in this case that will lead the hearing panel to find a 1.1 violation. The second...
Counsel, on the failure to provide diligence issue in this case, would you agree that we have to look at two different sets of standards, one set of standards being the guilt phase of a death penalty case, and the other being what standards of competence would apply to a penalty phase provision in a death penalty case?
I think one point, the analysis is under 1.1 and whether or not he provided competent representation during the guilt phase as well as the penalty phase, yes.
Right, but the standards are going to be different. I mean, when we look at penalty phase, we're going to want to look at what the profession views as the appropriate way to conduct a penalty phase proceeding in a death penalty case, right? And those are and those could be different than the kind of things you do to avoid a conviction in the penalty phase. Different standards.
I think the same analysis is present by whether the hearing panel or by this court, and that is whether or not he provided competent representation as to knowledge, skill, thoroughness, and preparedness, both in the guilt phase and the sentencing phase. I think that's the same. Now, granted that the attorney's role, a defense attorney's role in the guilt phase is much different than that in the penalty phase, and there's different factors to consider of whether or not those were met to meet the requirement of 1.1 of knowledge, skill, thoroughness, and preparedness. I mean, there's different considerations. For example, like in what's present in this case, the respondent is repeatedly testified, whether that was through an affidavit or depositions following the trial, or at the hearing panel, that he did not know that the Mr. Cheatham's prior voluntary manslaughter conviction could not be introduced by the state during the guilt phase. But it could be, obviously, as an aggravating factor during the sentencing phase. So that different type of knowledge that the defense counsel would have to have. So that's how.
Yeah, I mean, I think I'm just trying to make this simple. I think there, in all these examples, there might be different variations, but just to make it simple, you know, the type of mitigation evidence that's offered is only going to be offered in a penalty phase, and there are certain standards about developing that mitigation evidence, which is different from what you would do on the conviction side, on the conviction side of the guilt side of the case.
And I agree.
Okay.
And the testimony here is that he calls no investigation whatsoever. He was not prepared. He did not know about what transpires or what generally is presented during the sentencing phase of a capital case.
And my memory is that you had Reed Nelson testifying on behalf of the disciplinary administrator regarding the penalty. Part of his testimony was about the penalty phase standards. Was that the witness?
No, we had. I called Patricia Scalia, the director of the Indigent Defense Services, as well as the chief of the death penalty unit, Ron Evans. The second issue is there was a flat fee in this case, or whether or not the flat fee arrangement created a 1.7. There was no. The respondent did not reduce his caseload, his daily practice. He recognized that the Mr. Cheatham was indigent. He knew he was not going to get anybody, and he knew that, and the respondent was not going to spend his old money to do any type of investigation. So he did it.
As I understand it, the flat fee arrangement, the problem is that it was contingent on a not guilty verdict. Isn't that the problem here?
Well, the respondent says two different things. In his affidavit, he says it was a contingency fee arrangement that he would get paid if he was found not guilty. Later in the deposition and at the hearing panel, he changes that to a flat fee, and this court found in State versus Cheatham that confusion, the weight of the evidence supported a flat fee. And that flat.
Is it your argument that a flat fee is just unreasonable in a criminal case, or just unreasonable under the circumstances of this case? I
am not taking the position that a flat fee is unreasonable or anything is wrong with a flat fee in any case at all, other than under the facts of this particular case, okay, of the respondent's case. I rely on my brief for the third issue. I'm out of time unless now entertain any questions the court may have.
And the problem with the flat fee in this case, in your view, is that it is a disincentive for a lawyer to do much, if any, work, because a lawyer is going to get paid regardless.
That's correct, and it's clearly demonstrated in this case. Under 1.7A2, it says if there's substantial risk that the quality of the legal representation would be reduced because of the personal interests of the respondent, of the attorney. In this case, the respondent was running a very active political campaign for a statewide office. He testified that he had a high caseload. He had clients he was meeting with daily. He claims that he was in court daily in various counties. He did nothing to reduce that caseload to provide more time to the preparation of the capital case because those were bill payers and Mr. Cheever was not. So there was almost a per se disincentive in this particular case, under the facts of this case, not to provide, which resulted in a conflict of interest.
Any further questions?
I think I better ask one more. On the, attached to the respondent's brief was a document that he says his client wrote up about the defense. That was, do I understand correctly, that was not an exhibit at the disciplinary hearing, and so it wasn't offered as evidence at that time?
You are correct, Your Honor. At the disciplinary hearing, the respondent offered no evidence, period. He was called by me as, in my case in chief, and he answered questions and provided responses. But at the conclusion of my case, he arrested, and there was no evidence provided.
So what's your position about what we do with the document that's attached?
Well, there is cited in the brief, I have a string cite of cases that hold that's outside the record and shouldn't be considered. But my argument is that even if you consider it, it doesn't show anything other than, number one, I want my attorney to share with the prosecutor all my evidence, and there's nothing to be held back. And lastly, I understand he's running for a political office, and I don't object to that. And I do not think that is a waiver of any type of a conflict or any type of a consent that would waive any type of disciplinary rule.
And what is your recommendation for what we should do today?
My recommendation is that the findings of fact, conclusions of law be affirmed, and that you approve the discipline of disbarment, especially in light of the finding of the hearing panel that this was intentional violations of his duty to his client, Mr. Cheatham.
Any further questions? Thank you, counsel.
Thank you.
Mr. Robert?
I appear before you today dressed as Thomas Jefferson, who's my hero among the founders. And I wore this outfit because today the issue before you is whether or not the Constitution of the United States, as interpreted by the United States Supreme Court, has bearing on our rights. Very briefly, I had a right to represent Mr. Cheatham as directed, instructed, and agreed by Mr. Cheatham, no matter what the ABA guidelines might have to say about what the ABA thinks, which I'm not a member of, by the way, what the ABA says about how I have to practice law and present a double murder case to a jury.
I think I understand, I'm not saying I agree with it, but I think I understand your argument as it relates to the guilt phase of a death penalty case, but I don't see how it relates to the penalty phase. I don't see in this exhibit that you've attached, just let me finish my question and then you can...
I don't have a written statement by Mr. Cheatham regarding the penalty phase. I didn't get that. But Mr. Cheatham, maybe I wasn't smart enough to go to some sort of court services and get a shrink to talk to Mr. Cheatham. And perhaps in that case, I am deficient. And I had his mother testify, I believe, and I had some court services officers testify, and he was there. But I don't remember that much about the penalty phase. The guilt phase is where my constitutional rights and his constitutional rights come to bear.
I want to stick on the penalty phase here for a minute. Did your client didn't instruct you to tell the jury in the in the penalty phase, a jury that had just convicted Mr. Cheatham beyond a reasonable doubt of 2 homicides, but he didn't tell you to tell the jury that whoever killed these people should get the death penalty.
That's my view.
But
Mr. Cheatham didn't kill them.
I understand that your defense was innocence, but when you get to the penalty phase, there are other issues that are involved in a death penalty case. And I just want to be clear that it's not your position that Mr. Cheatham said that you should say that whoever they think did this should be killed.
That was my idea. I believe it, because Mr. Cheatham did not kill these women. In my opinion, that's why I took the case with no money up front, and I usually charge $5,000 per felony count, $1,500 per misdemeanor count, and I do a lot of criminal defense work, and have done a lot of criminal defense work ever since I started practicing.
Do you contend that Mr. Cheatham's instructions to you included not pursuing the cell phone tower transmittal?
No, I have no idea cell phones had GPS capabilities at that time. Did you? I didn't. If I would have known it, I'd have been on it like a dog on a bone. I just didn't know that cell phones had GPS capabilities, and I still don't know if they did have at that time. And nobody else has said they do, but I don't know. I know they do now. Almost everything does. I think your computers do. But I didn't know about cell phone GPS capabilities, or I would have used it immediately. I believed this man was innocent.
Did your instructions from your client include not filing a motion to dismiss based on the Marsh case?
No, it did not. But I want to go back to the reason I'm standing here talking or looking like Thomas Jefferson. And that is, the United States Constitution protects my rights to try the case as my client and I agree, especially when it comes to the guilt phase. And it goes like this. I represent a man who's charged with cocaine possession. He's a prior felon, so he's going to be severely sentenced if he is convicted of that. I get him out of jail on a small bond, and after the preliminary hearing, the judge allows him to remain unincarcerated. I walk into the hallway, and there are 2 police officers standing there saying, I'm going to get that. I won't use the word in deference to our place here, but they were angry, and they were stating to each other, we're going to get him. That lawyer, expletive deleted, got him out on the street. These police officers wanted him in jail because he had previously shot a man. I knew this. They knew that. I told my client, once we got out of the courthouse, I said, get out of town. I expect you to be back 2 days before the trial date with all of your witnesses, all of your proof, and all of your defenses. And this is on the cocaine case. He leaves town, I think. I don't know if he does or not. These 2 women are shot like a day later or 2 days later. And the 2 women are essentially sloppily murdered with like 3 or 4 shots, not an execution. All right. Another woman is shot 8 times, twice in the vagina, which I asserted to the jury was showing that another guy did it because the woman the eyewitness who lived was having a lesbian affair with one of the women that were shot and murdered, and her boyfriend showed up at the murder scene because he said, well, I was driving by and saw cop cars and I thought I'd come in. All right, so all of this is happening here. And Philip Cheatham calls me and says, I think they're looking for me on a murder case. I said, what? You know, I don't know anything about it, I'll try to find out. And so I spent some time, and I have some contacts, and I did at that time in the Topeka Police Department. They then bust Mr. Cheatham in Chicago with a .40 cal, which is what the murder weapon was on the 2 women that were killed, but not the same .40 cal. All right, they bring him back here. He says, I want you to represent me in this murder case. I say, you have to pay me a lot of money to do it because I don't want to take the responsibility. He says, on and on. Anyway, I hired on. No money. Because I do believe right now that he's an innocent man, and if I have to go through this in order to get him a new trial, okay, but I object. I think you got my lawsuit. Anyway, the point of this whole thing is that my actions, with my client's permission and consent and direction, are protected by the U.S. Constitution through my First Amendment rights and Mr. Cheatham's Sixth Amendment rights. And the U.S. Supreme Court has so stated, as I said in my briefs. That's the way it is. So the reason I'm dressed like this today is to determine whether or not you folks are going to implement and utilize the Constitution or no. I take that back. Whether you're going to pay attention to my constitutional rights. All these people out here, they all have rights too. They are in charge of defending those rights. I am in charge of defending my rights. This is a scenario where essentially the prosecutors are sitting on the jury because you guys prosecuted me. You sent it to your employee, Stan Haslett, and he gave it to Mr. Walczak, who has done a bang-up job here. Except for the fact that my client is the master of his case. That's what the Supreme Court says. And he knew what I was doing and how I was doing it throughout the entire thing. And I was even smart enough to get him to write a little about what our agreements were. And that's the attachment that one of you was talking about. So the question is, am I going to get you to protect my rights to represent my client, even in a murder case, the way he and I decide would be most effective? And just for the record, let me run over the defense. And this was the entire defense. It was my client was a criminal for a living. He sold crack cocaine and made a lot of money doing it, which he spent. But nevertheless, and another thing that, just to put this all into perspective, my client was born in prison. My client's mother was serving a drug conviction sentence when my client was born. His entire life, background, family, acquaintances, everybody that was available for me to call at any sort of final hearing on sentencing, they all were convicted criminals, felons, and I've been in court enough to know that if I tried to try Mr. Cheatham's case and say, well, Philip Cheatham here would never shoot two women. He did shoot one man earlier, but he would never shoot two women. And then shoot the other one 8 times. He would be a Boy Scout if he could have been. That wouldn't work. What I said was, Philip Cheatham is a experienced, extremely intelligent, and clever man. He is also a criminal, and if Philip Cheatham would have shot these 2 women to death in front of this witness, Philip Cheatham would not have left a witness alive to identify him. It's that simple. Who would, except the person that actually shot the women, who shot this woman 8 times until she agreed to point the finger at Philip Cheatham? Who would? And they would probably said they'll murder her mother and father and grandfather and everybody in the congregation. That's what made the woman testify against my client. And that, what you just heard, is essentially my argument to the jury. The jury came back about 5 hours later, I think, and I'm not sure how much time. And 2 women were sobbing and crying. And I was not smart enough to realize that these women had been under serious emotional or whatever pressure, abuse. And I didn't flash on that until later, and it was too late by then. However, I blame my client for the conviction, and I say that because he made me keep a black man on the jury. And this guy was a low-level executive at Westar, whatever it was then. And Philip said, no, we can have one black guy on the jury. So I left him on, even though my gut told, even though I had actually stricken him. And Philip asked me not to strike him. So this guy was on the jury. He became the foreman of the jury. And convicted my client, I think. Even though 2 women were sobbing when they came out to announce the conviction. So that's what I was dealing with. I may not have jumped through every ABA hoop, but because I believed my client was innocent, I did everything within my limited capabilities to persuade the jury that he was. And don't forget, Philip Cheatham didn't complain about my performance or conduct. You did. You are the people that accused me of incompetence, and if you had to accuse me of incompetence in order to get Philip Cheatham a new trial, I'll take it. Because he's innocent, and I don't want this state killing people that are innocent, and I don't want this state incarcerating people that are innocent. Maybe Val can do a better job than I did. Val Wachtel's going to try the case for him, and he's an old friend of mine. And another thing, I am incompetent. Anybody who believes that they are representing a innocent person and can't convince a jury of their beliefs that he's innocent is incompetent, obviously, or ineffective, at least. And I couldn't do it, even though I tried as persuasively as I'm talking to you. I don't know if you find it persuasive or not, but here I am. did my very best for Philip with his knowledge and consent. And I told the jury, with this man's background and experience, do you think he would have left an eyewitness alive? The woman was shot in the arms, the legs, and the vagina. Never in the head, the abdomen, the torso. She was left alive. And that's exactly the way I presented it to a jury. So, as you all know, I've sued you because I wanted to get your attention. My constitutional rights are more important than I am. They're more important than Philip Cheatham is. And they're being rapidly eroded in this country, and I ask you to stop. Please. Thank you.
You have any
Oh,
questions?
you have
of
questions?
counsel?
I'm sorry.
Any questions for the respondent? Thank you, Mr. Hoffer.
None? Oh, okay. Thanks, guys.
You reserved 4 minutes for rebuttal.
Chief Justice, unless I waive rebuttal, but I'll entertain any questions the court may have.
Any questions? I see none. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.